Hey, welcome back to the Law and Crime Network. We're hearing closing arguments in the Demetrius Elder case. The defense actually only called 2 witnesses. They had a list of 40 potential witnesses, but they only called 2. One person that witnessed the victim get out of the car, and the other was a friend of the defendant, Demetrius Elder, who said he actually saw the fight taking place. In studio with me is Brad Micklin. Brad, this is a little strange. You got 40 potential witnesses. You're looking at a manslaughter case. You're trying to say it was self-defense, and you only called 2 witnesses. What do you make of that?
It was shocking to learn that. I actually didn't believe it at first when they told me that because, again, there was 40 witnesses. If you listen to the defendant's opening statement, the counsel goes through a ton of people that he's planning to call, all these people that were involved in the fight. There was a toxicology report that says that there was PCP in the victim's bloodstream, and apparently none of that came out. I'm assuming that maybe the prosecutor just missed a significant element, and the defense decided just to go on that and not to push opening the door.
Yeah, I was thrown on the fact that they only called these 2 witnesses. We are actually going to go to a quick break here, but again, the closing arguments in the Demetrius Elder case are going on right now in Florida. It's a manslaughter case over an alleged road rage incident that started because of a fight or something like that. We don't know. A lot of moving pieces to this story, but we'll have more of the closing arguments here on the Law and Crime Network just after this break. Stay tuned. You don't want to miss it. Okay, we're still watching live the defense closing arguments in the Demetrius Elder case. A lot of moving parts. Still here in the studio with me, Brad Micklin. Brad, a lot going on here. You got this fight, you got weed, you got alcohol, you got PCP. But I want to touch on something. The defense, actually, one of the key witnesses in this case was a friend of the victim, Corey McMath. You heard him just say something about Corey being a convicted felon. What does that have to do with anything other than trying to discredit him as a witness?
I don't think it has anything to do with it. I'm actually surprised that it was found to be relevant whatsoever. But we have to assume this issue was raised pre-trial, and normally you would exclude evidence that's not relevant. So there had to be some showing that it would tie into it. Now, I know from the defense opening argument, at least, that they were trying to allege that Corey sort of instrumental in creating this, that he brought Muhammad in for the purpose of this fight. So maybe they were trying to tie together the kind of person that Corey is, having this violent past, and is more likely to have done something like this.
Yeah, and that very well could be. And you and I were talking while we were listening to this closing argument here. There's a chance, in my opinion, that maybe Demetrius does walk on this because there was just so much going on. It would be different if it was just a road rage incident and the horn blew, he got out, the fight occurred, and then there was a stabbing, but you had this party, you had this fight, you had alcohol, you had drugs. What do you think?
I agree. I mean, I don't think there was much testimony from the opening statements through the closing statements that really tied Demetrius to a weapon and to the fight.
Right.
And I think what might be really interesting now is Armando, I believe, gets tried next. And he's probably going to be able to say, it was Demetrius. It wasn't me.
Right, and maybe that's why they didn't call him as a witness. And you made a very good point there. Like, there's just so much going on, but we've heard several testimonies that said Demetrius was not even there when this whole thing started.
Right.
So it goes back to this whole manslaughter charge. He wasn't there.
Well, I think he was in the car. I mean, both the prosecutor's opening statement and the defendant's opening statement put him in the car, but neither of them seemed to tie him to, like I said a moment ago, to the weapon or to the fight. So it was really unclear.
Or to the fight. That's what I meant. He wasn't there during the fight.
Really,
and then, again, like we heard Corey say, Muhammad wasn't a violent guy, and I wouldn't allow that at my house. Just so many moving parts to this case. We have to take a quick break, but as I can see out of the corner of my eye, the defense is still on the floor. They're giving his closing statements. Hopefully we can get back to that here right after this break. You don't want to miss it. Things are heating up in that courtroom in Florida. Demetrius Elder is on trial right now for manslaughter. Stay tuned. We'll be right back right after this. Okay, still hearing closing arguments from the defense in the Demetrius Elder case, and he's been up for about 20 minutes now. Still in studio with me, Brad Micklin. Brad, you and I were talking, and the prosecution actually finished her closing statements in about 5 minutes. The defense has been up for quite a while now. Why do you think she was so quick in her closing argument?
My thought is that she's just not that good of a prosecutor. If you look at her opening argument, it was about 7 minutes long. I've argued motions that are 10 times that. And the defense opening argument was nearly twice that. But also, I think she might be trying to keep it closed because she has a death on her hands. She has some eyewitnesses. So maybe she's just trying to keep it more compact so that there's not reasons to argue reasonable doubt. I can't really tell yet.
Yeah, but she also can do a rebuttal once the defense finishes their closing arguments, correct?
Could be. I think some judges do and some don't, so we'd have to see what this one's going to do.
Yeah, now, with that rebuttal, like, I think she should have gotten everything she wanted to say out ahead of time versus waiting on this rebuttal because, I mean, to a juror that's going to say, well, why didn't you say that the first time? Why are you just now coming back? Were you not prepared? To your point, is she not that great of a prosecutor?
Well, if she knows that she's going to have this rebuttal, that may be different because I would certainly want to be the last thing that they hear before deliberating. So whatever points she has to make, whatever smoking gun she has, no pun intended, but she might be keeping that in her back pocket. So if she knows that she's going to close or rebuttal, then she's going to save that for that.
Yeah, and I think the defense is doing a really great job bringing out a lot of points and a lot of questions to make people have that reasonable doubt that they need to have in this case. Again, this is a manslaughter case in the state of Florida. Demetrius Elder is on trial right now. We're going to switch gears. We have a giveaway here at the Law&Crime Network, and it's pretty good. It'll be on your screen here in just a second. There it is. Enter for your chance to win the ultimate true crime giveaway. It's very exciting. Go to lawandcrime.com to enter to win that. You win 2 tickets to CrimeCon. That event is growing year by year. Next year it will be in New Orleans, Louisiana. So not only can you go to CrimeCon, you can get that good Cajun food. Trust me. You get a chance to meet Dan Abrams for a studio tour of the Law&Crime Network. It includes 1 night in a hotel and a travel voucher, so that's not bad. It's a great studio that we have going on right here. I will actually be signing off, but fear not, the guy with the pretty hair, Aaron Keller. Becky has nothing on him. He will be here. Brad Micklin will still be here in studio with us, and we'll have more of the Demetrius Elder manslaughter trial in the state of Florida. The defense is still giving his closing arguments. Stay tuned to the Law&Crime Network. We'll be right back.
Welcome back, everybody. The prosecution just wrapped up its closing argument rebuttal in the Demetrius Elder manslaughter case in Florida. The jurors are being sent back to the jury room after a few quick additional instructions from the judge. They got the bulk of the instructions earlier today, so the jury is going to be on the clock very, very shortly in this case. The prosecution basically saying, in summary, that this discussion, which started at a stop sign, was a gesture of peace, in the prosecution's words, from the victim to the defendant. The two had been at a party together. They wound up stopped at a stop sign, one behind the other, when the victim got out of the car. Now, the defendant said that he and an accomplice thought that it was an attack and that they were attacked. That's one of the defendant's versions of the story. The prosecution said, no, that's not the way it went down at all. It was a gesture of peace when the victim got out of a vehicle. That victim wound up getting attacked and stabbed. The defendant said he thought that the victim had a weapon. It turned out to be a plastic cup. The prosecution told jurors not to buy that theory, that it was an excuse after the fact for an attack. This is an interesting case. The jury really has a lot of factual calls to make here. That's what juries are for. And this case has got a lot of he said, she said, a lot of conflicting facts that jurors are going to have to resolve. Brad Micklin is an attorney. He's here with us. Brad, good to see you. I appreciate you being on. So what do you make of this? This is a lot of factual back and forth for the jury to really dive into here.
Well, I think part of what's going on sort of both sides, I mean, obviously we have a prosecutor who's trying to prove manslaughter, which isn't the highest of burden, but we have obviously a defendant who's looking to prove reasonable doubt. And I think that's what we heard more about, because the prosecutor's rebuttal sounded more like she was on the defensive as opposed to trying to establish the act that led to the manslaughter. So when you look at the defendant's case, where we have Muhammad on a combination of drugs, one I believe being PCP, and all these other people, Corey and Demetrius, and this alleged history of the fights and the revenge, as they so called it, I think you're really creating a lot of potential reasonable doubt. And I think that's what the prosecutor was trying to work against in the rebuttal, as opposed to just establishing the manslaughter.
Yeah, it's interesting. And you know, a lot of people are like, well, this isn't a long, drawn-out closing argument. We often see them. But manslaughter doesn't have a lot of elements in Florida. They don't have to prove premeditation the way they would in a first-degree murder case in Florida, or they wouldn't have to prove in Florida on a first-degree murder that it was a murder that happened which was attached to some other underlying crime. Okay, so the burden for the state here is a lot lower than it would be in a lot of the other types of crimes that we follow. Could that account for the comparative brevity, I guess you could say, of the closing arguments here?
I think so. I was on a moment ago with Vincent before you signed on, and he and I were talking about that. I'm not a big fan of the prosecutor, at least how she handled a lot of parts of this case. But I think, I don't know if it was her decision or the office itself, but I think the not charging murder and charging manslaughter was actually a brilliant choice, because the whole, this is a revenge fight that the defense was bringing up, they could have flipped it and used the same type of argument that this was a revenge killing and gone for murder. And I think that would have been a hard charge to sell to a jury given this convoluted fact pattern. So I think the manslaughter made a lot of sense.
Yeah, exactly. Who did what, when, why? What was going on at this party? Was the victim, who went by the nickname Mohammed, was he there to settle a dispute? Was there something going on? You know, and in whose mind are we looking? Are we looking into the defendant's mind? Are we looking at the stereotypical reasonable person standard? Would a reasonable person have felt threatened by this action? You know, this is late. This is a stop sign. Why somebody who was at a party, who allegedly was there to settle a dispute, suddenly coming for me? The defendant might have been wigged out in that situation. You know, is it reasonable? A lot for the jury to really dig into here. We're going to be talking a lot more about the Demetrius Elder case in Florida when we come back here on Law and Crime. But first, we want to get you caught up to speed on some of the top crime stories of the day.
Here are today's top crime stories trending on lawandcrime.com and across the country. Is this thing dangerous? A Texas SWAT team came across a heavily armed scarecrow while raiding a pot plantation in Richland, Navarro County. Police described it as a fully dressed figure lying in a hammock, appearing to be armed, holding an assault-type rifle, appearing to provide security for the location. The raid of a 5-acre plot netted some 10,000 pot plants, some of which were 6 feet tall. We don't know the height or weight of this suspect, but we suspect he had no trouble asserting his right to remain silent. Now to New Jersey, where body cam footage shows a commuter train barely missing a trespasser on the tracks. Stop the train! Move! Move! Officer Kyle Savoya is being hailed as a hero for saving the dazed man. Savoya was there for a welfare check. Dispatchers told him there'd be a man on the tracks, but he didn't realize a train was so close. It's unclear what was wrong with the man, but he did show up at the police station later on to thank the officer. And in Colorado, a 31-year-old woman is under arrest for stabbing her fiancé to death with a steak knife. One version of the story that defendant Jacqueline Souza gave to police is that her fiancé, Brandon Watkins, wanted to invite a strange guest to their wedding. It was a woman he had had an affair with years earlier. Police say Souza claimed the invite led her to suspect the affair was going on. Souza was apparently in the process of divorcing her own husband while planning an upcoming wedding to Watkins. She'll be in court for the first time on August 1st. Those were today's top crime stories. I'm Anthony Velez for Law and Crime.
Welcome back, everybody. We are talking about the case wrapping up today in the Demetrius Elder manslaughter case out of Florida. Jurors got the case about 10 minutes ago. We're waiting to see how quickly they may or may not come back with a verdict. So, Brad Micklin is an attorney. He's here with us on the Law and Crime Network. Breaking this down a little bit, we've got a lot of different factions of people testifying, and what we listened to right before the break was a friend of the victim, and he's saying, oh, no animosity, there wasn't anything bad going on, but I would expect when there was cross-examination of him that he would have been impeached because he was a friend of the victim. He's probably not going to get up there and say the victim is an aggressor.
Right, well, that's one of the pieces that didn't make a lot of sense to me. Aside from, and I know I commented before about the prosecutor, and I've never been a prosecutor, and I understand it's a challenge deciding who to charge, what to charge, when not to charge.
And you don't get to pick your witnesses.
Right.
That's the other struggle.
But here we had a witness that apparently was brought in by the prosecutor. I had two issues with the testimony. First was, if you listen to her examination, most of it was open-ended questions. Yes or no's, or I mean closed questions, like leading questions, yes or no's, where it's supposed to be open, who, what, where, why, when, and how. And she's leading the witness as opposed to examining and walking them through the testimony, but the defense didn't say a thing. So they let it go, but then the testimony itself almost seemed like she was trying to negate what the defense was going to be bringing out, that this was a revenge killing, where her job is just to establish that there was death. So I didn't even understand why she would call this witness as her own.
Well, you know, you get into a lot of sort of funky procedural things in Florida, because I did read some of the pretrial documents in this one. This case happened before the current incarnation of Florida's Stand Your Ground law. And there's a lot of litigation in Florida about it, just exactly how far back that new law can be used as a shield by a defendant in court, sort of retroactively, because there's an incident, then the law changed, and then trials happen. So it's like, is it a procedural rule or is it a substantive rule? And there was a lot of back and forth about that. So some of the jockeying I think we were seeing was a result of that. You know, once the defendant says, Florida, stand your ground, it puts the prosecutor on, you know, if not an additional legal burden, then certainly an additional edge to try to override that claim by the defendant. And we watched that play out in closing arguments. I think that some of that was what we may have been watching.
Yeah, that might have been, because most of the reviews that I've heard about this case did characterize it as a stand your ground case. And I know it's very controversial in Florida, so I thought that's what the defense was going to be bringing out. And then again, all we keep hearing from the defense is that it was a revenge killing. So I was kind of confused at what the actual theory was when you listen to the opening arguments, where they're supposed to be sort of mapping out not only the land of the testimony, but what the theory of the case is going to be. You didn't really hear this stand your ground claim come up at all.
Yeah, we're going to get back to the testimony, though. This is Corey McMath. He was a friend of the victims in this case. The victim went by the nickname Muhammad. Here's some of his cross-examination. Boy, we were getting into a lot of back and forth there about all kinds of stuff with the friend of the victim there. Bring in Brad Micklin into the discussion here. So it was interesting. That's cross-examination. We heard more open-ended questions on the cross than we did on the direct. It seems like the defense wants to just let him tell a story, because he's talking about drugs that they were taking, and he was sort of digging his own grave from the witness stand.
Yeah, that's how I heard it too. I mean, he first appeared when he was testifying for the prosecutor. It was very credible, even though he was being led to his answers, because it was a fleeting answer, but he admitted to smoking marijuana. So to some extent, while that might not be the best thing to admit, at least he's credible. He's not hiding behind a different type of story.
He's not lying about it, but, you know, does that affect his perception of the events that he's testifying to? He's saying, you know, oh, the victim is peaceful, this, that, and the other thing. Well, if he's high on marijuana, does he really know what's going on?
Well, and I still have trouble seeing the relevance of this in the first place. He wasn't there. He testified he didn't even see it. The altercation happened down the street, if not further. So other than this revenge killing that the defense is trying to bring out, which I don't even know if they need to establish at this point, I didn't see the point of even calling this witness from the prosecutor's standpoint.
Yeah, it seems like the defense is trying to say that there was an altercation that was brewing at this party. It spilled out into the stop sign, and this witness, the prosecution is trying to use to say, well, that didn't happen. Well, look, we're going to take a quick break again here on the Law and Crime Network. Back with more on the Elder case in a moment. Testimony from the victim's girlfriend about how this fight broke out in her version of the events here. So we've got a couple different versions of events here that jurors are going to have to try to weed through. Brad Micklin is still here with me. Brad, what do you make of this? Is she credible? Is she covering for the victim? How should jurors take this?
There's a lot of layers to a witness like this, because we have to acknowledge that she's a victim herself. I don't know how long-standing her relationship was, but she's certainly a victim. But that also gives her some incentive to see things differently. I'm not suggesting that she's going to lie or change the facts, but her perception is certainly going to have a different perspective, because she wants to vindicate her boyfriend's life. And I can't see that as causing her to be consistent with what maybe other eyewitnesses might have seen.
You know, one thing that strikes me in listening to her version of the events is she's saying it's not so much the defendant as it was the other person who, you know, could be described as an alleged accomplice here, because the defendant and another person were in one vehicle, and then it was the girlfriend and the victim in another vehicle. It sounds like the first punch, if we're to listen to and believe her version of things, wasn't this defendant.
Right, and that's the problem I've had with this case since the opening statements, is that I haven't heard either side, the prosecutor or the defense, actually tie Elders to the stabbing or even to the weapon. So this whole road rage issue or revenge killing, whichever one it was, doesn't necessarily involve Elders, at least at this point that we're hearing.
Is this a situation where Elder is going to be able to say, hey, look, these two start going at it, it spills over into me as that girlfriend just testified, and then at that point, everybody's throwing punches, and at that point, I have to defend myself?
That could be, but obviously I don't believe he testified, which I think was a good choice, because you don't want to take the stand as a defendant in a manslaughter case unless you absolutely need to, and as a defense attorney, it's rare that you're going to do that. So while he could have, it's smart that he didn't.
All right, we're going to pick up our testimony with the girlfriend, Wendy Gembelis, where we left off. Welcome back, folks. That was testimony from one of the detectives in the Demetrius Elder manslaughter case in Florida. Jurors have that case right now. They've been deliberating for close to 45 minutes at this point. No clue how long they'll go this evening. No clue if they'll resolve the case today or whether they will push deliberations into next week. We are waiting to see. Brad Micklin is still here with us on the Law and Crime Network. And Brad, look, here we've got some testimony from a police officer saying that the aggressor here, according to the victim's girlfriend, really didn't have any kind of wounds on himself. So does this lend credibility to that girlfriend whose testimony we listened to a little while ago, where she says this basically was her boyfriend who was bearing the brunt of the injuries here? It wasn't the person she says was the aggressor.
Yeah, I think it scores several points that the prosecution wants to make. I think, first, the officer identifying the solo cup does sort of set the tone that he got out and maybe he was going to shake his hand. He didn't have a weapon in his hand. But also, there was testimony that they had to find the car and that there wasn't any marks on this. And I think that's going to open up a claim that they fled the scene because they knew they did something wrong.
Yeah, this is an interesting piece of testimony to plug into what we heard earlier. But look, how long ago was this fight from the point that they served the warrant and then try to examine this guy? Is that, I'm sure that it's been discussed. I just must be missing it in here somewhere.
Well, I think that's going to be either something that comes later or something that we hear with cross-examination. I think the defense counsel is going to be charged with also showing what the police officer didn't see or isn't qualified to determine. He's not a medical officer or medical educated in any way to know whether there would be a bruising and how long it takes for that to surface. And things like that, I think, are going to be subject to the cross-examination.
Exactly. Well, we are continuing to listen in to see what's happening in the courtroom. No activity yet from the jury. But look, we're going to be here to wait and see what happens. More here on Law and Crime after this. Okay, folks, we're back. We're going to talk about the Anthony Kirkland case here. Brad Micklin is still with us on Law and Crime. This is certainly a bizarre procedural twist. And those of us who are members of the bar sit and say, how rare is it for, first of all, a hearing like this to be flipped, but how even more rare is it for an appeals court to look at it, not flip it, and then look at it again and then say, wait a minute, we should have done it a different way the first time around. That's what's really rare.
Yeah, I think this is an exceptionally rare case. I think it's rare that you're going to see anything close to this. If this wasn't a death penalty sentence, I don't think it would have been reversed. The sentence or the phrase that the prosecutor made isn't bad enough to overturn, I think, what I'd call your average conviction or your lesser offense. But because the capital murder case always has such a heightened scrutiny from the beginning selection of attorney through the sentencing, that's what led to this reversal.
Yeah, there were a series of things that the prosecutor said, and the most serious one of them all. And I encourage everybody to take a look at the opinion. We've put it in the chat room before. It's worth reading the opinions because it gives the roadmap of exactly why certain things were said during the opening statements in this case. The most serious thing the prosecutor said is, hey, look, this guy's been convicted of all these other murders. If you don't send him to death row, he's going to get a freebie on the two that you just convicted him of in this case. And, look, I mean, that does rub me the wrong way. I mean, that's you know, the punishment is supposed to be determined based on the individual crime with sort of blinders on. This crime, this punishment, without too much looking around at what's going on sort of back in the periphery back here.
Right. Well, here you have a prosecutor prosecuting what was described as a serial killer. I mean, he has 5 murders to his name. He had served one time and then came and killed 4 more. So it's easy to understand why a prosecutor is going to be a little more zealous in a closing argument or during the presentation of the case. But to turn it back, between the burden on the family and all the victims that have to come back, the burden on the state because there might have been a few overzealous statements, is just almost unconscionable.
Yeah, I mean, well, that's a strong word. I don't know if I'd have gone quite that far. It sounds like you're sitting in the prosecutor's shoes at this point.
I think so. Again, you have a serial killer, and I think he was a serial killer. He was convicted on 1, admitted to 2, and got convicted on 2 more. This person should be put to death, and I think that even with this reversal, that he will be.
That's strong. That's strong. You know, look, I'm waiting to see exactly where this is going to go, and in part of what the prosecutor's doing in this particular hearing, which may be different from the tactic in the first one, the opening statement was read verbatim off of a script. My guess is that he wanted no issue this time around. He doesn't want to come back a 3rd time.
Right. He's not taking any chances. I mean, aside from, I'm sure, his own desire to make sure this person gets the punishment that's deserved, he's got constituents to answer to. This is his job. He needs to ensure that it's done right. And the only way to do that is by making sure it's in writing and that you stick to the script.
Yeah, exactly. Look, I mean, I'm not trying to make excuses for this defendant. This guy did bad stuff. I mean, it's one of the worst defendants that I think we've come across here on Law and Crime, and we cover murder cases all the time. You know, some of them you look at it and say, did the person have a fit of rage? Was it something that set the person off? You know, this is a defendant who in the interrogation, which we're partway through in court at this point, is kind of bragging about stuff. You know, what's going on in this guy's head? Do we really want to know?
Yeah, I certainly don't want to know. And, you know, the strange thing about, well, one of the many strange things about this is, you know, the defense opening argument indicated that there's going to be psychiatric and psychological testimony about his inability to control his emotions and his abusive past. But yet I don't imagine that there was any kind of competency issue for him to stand trial. I don't think there was any, you know, reason, innocent or not guilty by reason of insanity. So to bring this evidence in now, it almost makes no sense to me.
Yeah, look, we're going to go to some of the clips from this particular case, the Anthony Kirkland case in the Cincinnati, Ohio area. Again, a defendant either admitting or being convicted of committing 5 murders. We're back for a rehearing of what his punishment should be on 2 of those crimes. Let's listen to testimony from Keith Witherell. Testimony there from previously in the Anthony Kirkland sentencing hearing. Again, a defendant in that case convicted or admitting to 5 murders in the Cincinnati, Ohio area. The question for this jury is what his punishment should be. This is a rehearing. He was initially sentenced to death, but they have to do it over again because the prosecutor overstepped his bounds in the initial hearing. Also want to keep you folks up to date on what's going on in the other case we're covering, the Florida case. This is the Demetrius Elder case. Jurors apparently have a question in that case. We're monitoring the courtroom. Nothing big happening yet. We're going to wait and see what that question is and discuss it if and when it's something big. So we're keeping a close eye on that one, too. I know that you folks in the chat room are also watching it closely. So, Brad Micklin, you always want to know when jurors have a question. You try to gaze in the crystal ball and figure out which side they're on because it eases the tension that the attorneys are feeling right now at this point when the juries have the case.
Yeah, it makes you wonder at this time, this late in the afternoon on Friday, if their question is, you know, if we don't make a decision, can we just go home? But there could be a million different things. They could be asking about the definition of one of the intents that need to be met. They might have a question about a fact situation that maybe they don't have the proper recollection of. There could be a million things that they're asking about right now.
It could be. We're going to keep an eye on that situation, folks. In the meantime, we're going to take a quick break here on Law and Crime. We'll be back with more discussion on Demetrius Elder and also in the Cincinnati case in a moment. Welcome back, folks. We are monitoring the situation in the Demetrius Elder courtroom in Florida. Jurors there apparently have a question, but they're not back in the courtroom yet, so people are sort of gathering, and we're waiting to see exactly what this question is. For all we know, it could be we want dinner menus. It could be, do we have to come back next week? It could be something much more critical, like a readback of testimony or a further explanation of the law or something of that nature. So we're still waiting to see exactly where they're going to go with this particular question in that courtroom. I don't know. Brad Micklin, what do you think? What do they want?
I have no idea. Again, it could be they'd want to go home, or like you said, they could want to order dinner, or they could be uncertain about the charge or the intent that's required. It could be one of a million things.
One of a million things. So right now, nothing big going on. People are sort of in and out of the courtroom. So we're going to continue listening to previous testimony in the Anthony Kirkland case in Cincinnati, Ohio. That case wraps up a little bit earlier in the day. They usually go till about 1:30 in the afternoon. That, of course, is the death penalty rehearing in Cincinnati, Ohio, against the defendant. Look, this guy, you name it, he did it. 5 murders. He either was convicted of committing or admitted to committing. Now jurors have to figure out what his punishment should be in 2 of those murders. A previous jury convicted him of those 2 counts earlier, but the Ohio Supreme Court flipped the original death sentence because the prosecutor overstepped his bounds in closing arguments in that case. So while we wait to see what's going on right now in Demetrius Elder in Florida, we're going to listen to some of the defendant, Anthony Kirkland, what he had to say to police in an interrogation. And welcome back, everybody. That was a playback for jurors in a death penalty hearing for Anthony Kirkland, a defendant in Ohio who is facing that hearing for a second time. He was originally sent to death row by an original jury which convicted him of 2 murders. The Ohio Supreme Court decided that the prosecutor just went too far in that original hearing and ordered a second sentencing hearing. Those were some of the defendant's own words, and he was sort of setting up being in the park where one of the 2 murders was committed that he's facing, at least in this particular hearing. He already had either admitted involvement or been convicted of 3 other murders apart from the 2 that are the subject of the instant hearing. So that's what we were listening to in that particular case. We're going to switch over, though, back to Demetrius Elder, that manslaughter case in Florida that we're following, because jurors there asked a question of the judge, and this was no surprise if you've been listening to what I've been saying all afternoon, and I know Brad Micklin was, because he's sitting right here across from me, and he's paying close attention. Jurors have a lot of facts to try to reconcile, and what they asked for was a transcript of testimony from Wendy Gimbolas, who we were just listening to, the girlfriend of the victim, and they wanted a transcript of the defendant's own testimony from a stand your ground hearing. They are trying to reconcile whose version of this attack at the stop sign makes the most factual sense. The judge said, look, you can get a playback of the video, but there is no transcript and evidence, and you can get a readback of Wendy Gimbolas' testimony. He said it might take a while, so this might push into next week from a timeline standpoint. But look, 2 different versions of what went down there, the defendant's and the victim's girlfriend. Who should the jury believe? And of course, we don't know the answer, but it's the rhetorical question. They're trying to reconcile that testimony.
Well, that's the jury's job. So when they ask to see something, you would hope that they would be able to get it, especially in a typed form, so there wouldn't be any question of interpretation or recollection. Now, I believe this is more of a technicality where the judge said you can watch it. You can't read the transcript because we didn't move it into evidence, but having to watch it means you have to watch all of it, or at least large portions of it.
Yeah, I mean, look, but I think the jury's doing what the jury is supposed to do. And ironically, of course, they're asking for pretty much the same exact stuff that we were playing back earlier today, trying to reconcile the facts from the 2 people who were there at the scene. That's exactly what they're trying to do. They want to hear from the defendant. They want to hear from the other person who was there. We are going to take a quick break here on the Law and Crime Network, though. We're continuing to monitor Kirkland and Elder. We'll be back in just a second. Jurors in the Demetrius Elder manslaughter case basically asked for some of that exact testimony to be played back. That's part of his version of what led up to this stabbing at a stop sign after a group of people, the victim and the defendants, were at a party. Jurors are trying to reconcile that with testimony from the victim's girlfriend that does not line up with that testimony. So, Brad Micklin, this is the whole reason we have juries. They have to reconcile who's telling the truth and who's not.
Right. I mean, and both sides of this case had some strange aspects to the story that left me with questions. You know, and when you're looking to the defendant taking the stand your ground defense, They were the car in the front. They were at a stop sign. The question, why didn't they just go? You know, their refusal to move seems to what brought this about. So that is what drives weird about their whole position. But yet the defendant's position is, I got out holding a Solo cup and went to shake his hand. That doesn't make sense either. So I can understand why the jury is going to have trouble reconciling both of these stories.
Yeah, exactly. You know, and I thought, if I'm remembering my facts correctly, didn't the car behind sort of pull up and then beep, and then, you know, so it's like, what did the person in the front car, if we're to believe the defendant, did he think that somebody back there was trying to get his attention for some reason? And if this theory that there was some animosity brewing at this party, if that was correct, maybe he was on edge instantly because of the beep. He knew what was going on. Well, we're going to wrap up the broadcast today in just a minute. Brad Micklin, we appreciate you being here. It's great to have your analysis. So, want to remind everybody that there's a giveaway going here at the Law and Crime Network and on lawandcrime.com. Enter to win the ultimate true crime giveaway. 2 tickets to CrimeCon. That's a convention with real crime themes. Many of your favorite authors, podcasters, and some of us. You can win the tickets. Meet our founder, Dan Abrams. He's everywhere these days. Go to lawandcrime.com if you'd like to sign up for your chance to win for that. We are continuing to monitor a couple of cases here, but we're going to sign off for the day here on the Law and Crime Network. If you'd like to continue to monitor Elder, go to lawandcrime.com, click on the live tab. You can see the raw feed coming in. We're going to wrap up for the day, though, right now. A reminder, we are live from 9 to 5. This is Aaron Keller, and for everybody at Law and Crime, have a great weekend.